Welcome to this explainer. Have you ever wondered what actually happens when a judge bangs that gavel? The final word is supposedly spoken, but the decision just feels completely wrong? I mean, we are all taught to respect the court's decision, right? But the people making those decisions are human, and, well, humans make mistakes. Today, we are breaking down the ultimate legal remedy playbook to figure out exactly how the justice system goes about fixing its own errors.
So, if a court messes up, is that just the end of the line? The short answer? No, definitely not. Fortunately for all of us, the legal system isn't completely blind to human error. It actually has these incredibly precise, built-in mechanisms to correct mistakes. But here's the catch, and it's a big one. You can't just storm into a courtroom and yell, "I object." You really have to choose the exact right legal pathway, because if you pick the wrong one, you could literally lose your chance at justice forever.
So, here is our roadmap for today. First, we will look at appeals, then reviews, third, revisions, and finally, quashing FIRs. Let's dive straight into Section 1, Appeals, the right to challenge.
Basically, an appeal means you are asking a higher court to look at a lower court's decision all over again, simply because you believe that decision was fundamentally wrong or unfair. It is what we call a statutory right. This means that unless the legal code specifically prohibits it, an aggrieved party has a very real, substantial right to demand this second look. And they can challenge the facts of the case, the judge's interpretation of the law, or honestly, both.
Let's put this into perspective. Imagine a guy named Ravi. Ravi gets convicted by a lower court for theft and is slapped with a 3-year prison sentence. But Ravi firmly believes his trial was completely unfair. Because he has that right to appeal, he can file a petition in a higher court to challenge not just his conviction, but also the severity of that 3-year sentence.
Now, you don't just take the elevator straight up to the highest judge in the country. There is a strict hierarchy here. It's like a ladder. A conviction by a magistrate usually goes up one rung to the Sessions Court. If the Sessions Court convicts someone, especially with a heavy sentence of over 7 years, that case climbs up to the High Court. And ultimately, in some very specific, extraordinary circumstances, an appeal can go all the way to the top, straight to the Supreme Court.
What's really fascinating here is exactly who can appeal. It's absolutely not a one-way street. Yes, a convict like Ravi can appeal to say, hey, I am innocent or my punishment is way too harsh. But the victim or even the state government can appeal too. If an accused person is set free or acquitted and the state thinks that acquittal is completely wrong, they can appeal it. And get this, even if the state decides not to bother, the victim still retains an independent right to appeal that acquittal or even argue that the compensation or the sentence given to the convict was just a slap on the wrist.
So, while appeals are incredibly powerful, they definitely aren't unlimited. For instance, if an accused pleads guilty right out of the gate, they generally cannot appeal their conviction later. They might only be able to argue about the legality of their sentence. Also, under the new BNSS criminal code, there is a major push for efficiency. Appeals are actually meant to be wrapped up within 6 months. And what if you've exhausted all your normal routes? Well, that brings us to Article 136 of the Constitution. This is a massive discretionary power that allows the Supreme Court to grant special leave to appeal from almost any court or tribunal in India, even if no other appeal is allowed by standard law. It is kind of the ultimate wildcard.
Moving right along to Section 2, Reviews, Fixing Apparent Errors.
So a review, which falls under Section 403, is fundamentally different from an appeal. With a review, the exact same court that passed the order looks at its own judgment again. Let me be clear, they are not doing this to re-argue the facts of the entire case. Not at all. They're doing this purely to correct material, often just clerical, errors that are blatantly obvious right on the face of the record. We are talking about mistakes that would lead to a total miscarriage of justice if they were just left unfixed.
Take Rahul's case, for example. A Sessions Court convicts him, but when they're typing up the judgment, the court makes a super obvious mathematical error in calculating how long his sentence should be. Instead of making Rahul go through the massive hassle and expense of a higher court appeal, the original court can simply review its own judgment and fix that math mistake. It's quick, it's efficient, and it is strictly limited to those super obvious errors.
Next up, Section 3, Revisions, Correcting Procedural Flaws.
Now, a revision is a really fascinating tool. It is purely a discretionary power used by a higher court, usually a Sessions Court or High Court, to correct a legal irregularity or a jurisdictional error made by a lower court. You actually don't have a statutory right to a revision. It is entirely up to the higher court's discretion whether they want to take it up. It is mostly used to ensure the lower court played by the rules, especially when the law doesn't explicitly give you a clear pathway for a standard appeal.
And honestly, this remedy can be an absolute lifesaver. Suppose a magistrate completely ignores proper procedure and wrongly dismisses Priya's complaint without even giving her a hearing. That's rough, right? Priya can't file a standard appeal for that specific action, but she can file a revision petition. The higher court will look at this, realize the lower court completely dropped the ball on procedural law by ignoring her, and they will send the case back down for a fresh, proper hearing.
Because it is such a laser-focused tool, the rules for a revision are incredibly strict. It focuses purely on the legality and correctness of the proceedings. Is there manifest illegality? Was there a blatant violation of procedure? If yes, then a revision applies. But keep this in mind. Absolutely no new evidence is taken here. The court is only looking at the existing record. Interestingly enough, a court can even initiate this suo motu, which means on its own, without anyone even asking. But there is one massive hard boundary. A higher court using its revision powers cannot magically turn an acquittal into a conviction. No way. The most they can do is order a retrial or a rehearing.
All right, Section 4, quashing FIRs, the catch-all.
Under Section 528 of the BNSS Procedural Code, we find this incredibly broad residuary power. This is basically the catch-all petition used when absolutely no other remedy exists. What makes Section 528 so incredibly powerful is that unlike a revision which only targets court orders, this provision can actually be used to target and stop police actions too, like the very filing of a First Information Report, or FIR.
To really grasp the gravity of this, we have to look at the landmark State of Haryana versus Bhajan Lal case. Bhajan Lal, a former chief minister, was accused of corruption. Instead of going through the normal motions, he went straight to the High Court, asking them to quash or completely terminate the FIR against him, claiming it was entirely malicious and an abuse of power. This case went all the way up to the Supreme Court, and ultimately, the Supreme Court upheld the inherent power of the High Court to quash an FIR, specifically to prevent the abuse of the legal process.
However, the Supreme Court firmly warned that this power is basically a legal nuclear option, and it must be used very sparingly. So they established the famous 7 Bhajan Law guidelines. Basically, a court can quash an FIR if the allegations clearly don't even amount to a cognizable offense, or say if the police are investigating a non-cognizable offense without a magistrate's order. It can also be used if the claims are inherently absurd, maliciously instituted just to get revenge, or if there is an explicit legal bar to the proceedings. It is a vital safeguard to ensure the machinery of justice isn't weaponized to harass innocent people.
Finally, Section 5, comparing your legal options. When we actually map all these out side by side, the distinctions become super clear. An appeal is your statutory right to argue both facts and law up the judicial ladder. A revision is a discretionary favor from a higher court focused purely on legal and procedural errors. And a review? That stays in the exact same court just to fix obvious clerical mistakes staring right at you from the page. Knowing these boundaries is absolutely crucial. It is the key to diagnosing and fixing a legal error effectively.